do.
Can you dig it? Can you dig it? Can you dig it?
Hey, yeah, boy.
Touch this.
What's up? We back at it again. You already know it's power inherent all in the people. You are the people. So in this one, on part 3, we're going to be getting into the title of nobility. We're also going to be showcasing case law, or should I say the dismissal in relation to my court cases that I've won thus far. So we're going to get involved in the paperwork. You can see it firsthand from what I filed and how I've won. Because everybody wants proof instead of just being bold and going and doing it themselves. We'll show you. I would never present false information, misleading information on something that hasn't worked for me. So we'll show you that as well. So we're continuing on in this third part on the title of nobility. So, the Constitution for the United States of America at Article 1, Section 10, Clause 1 prohibits the granting of a title of nobility, meaning that no state shall grant title of nobility. Since the granting of a title of nobility is absolutely prohibited, this court lacks subject matter jurisdiction to enforce a title of nobility and its attendant rules and regulations. The Supreme Court, as far as Utah, has stated that the, quote, ability to drive a motor vehicle on the public highway is not a fundamental right, but a revocable privilege. City of Salina versus Wisden. The distinctive appellation, designation, or the title driver is a title of privilege, a title of noble privilege, a title of nobility. Okay, guys? In the words of Thomas L. Wilmore, city attorney for the city of Tremonton, Utah, case number 94-0336, Tremonton City Justice Court, quote, a title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title, rather than to the title itself. Words and phrases. Volume 8A, page 40. A driver's license is a privilege which is granted by the state, a municipal corporation, unquote. In other words, to obtain a driver's license is to be nominated to an order of persons known as drivers and be granted the special privileges that attach to the title. The United States Constitution at Article 1, Section 10 prohibits the states from granting a title of nobility, i.e., a driver's license, and its attendant rules and regulations. Pursuant to City of Salina versus Wisden, the driver's license and its attendant rules and regulations are by definition a title of nobility. Article 1, Section 10 of the United States Constitution prohibits the states from granting a title of nobility. The court lacks subject matter jurisdiction to enforce upon the defendant title of nobility. What is prohibited to the states is forbidden to the court to enforce. California Motor Company versus Trucking Unlimited, 1972. Therefore, the accused requests the court to make a legal determination as to what is a title of nobility. The following case law will define a title of nobility for the court to use to make its determination. The following quote gives the answer. Quote, nobility, an order of man in several countries, to whom special privileges are granted at the expense of the rest of the people, unquote. Bouvier's Law Dictionary, 1870. And, quote, to confer a title of nobility is to nominate to an order of persons to whom privileges are granted at the expense of the rest of the people. It is not necessarily hereditary, and the objection to it arises more from the privileges supposed to be attached than to the otherwise empty title or order. Horst versus Moses. Corpus Juris 598, Nobility Note 4, 1874.
Hey, yeah, boy.
Bovier's Law Dictionary. Nobility. Quote, these component terms, privilege, honor, and emolument, are collectively in the term title of nobility. Horst versus Moses, 1872. And government granted entitled privileges such as driver's license and its privileges are obviously noble entitlements and franchises, as pointed out by Richard B. Stewart, left-wing politician, Rhodes Scholar, and Harvard professor. Quote, the third great innovation in American administrative law, which has largely occurred during the past 20 years, extended the procedural controls and principles of judicial review developed in the context of regulatory decision-making to the operations of the welfare state, including programs of government insurance and assistance, government employment decisions, and the administration of government grants and contracts. Under traditional private law principles, these benefits were privileges and not rights, because their withholding did not constitute the commission of a tort or other natural law wrong against a disappointed applicant or terminated recipient. With the growth of the post-World War II welfare state, the distinction between rights and privileges gradually eroded. Statutes conveying these various benefits and advantages were held by courts to create entitlements. Unquote. The Limits of Administrative Law in the Courts, Separation of Powers, Final Report on the 1983 Chief Justice Earl Warren Conference on Advocacy, page 77, Library of Congress, number 83-061923. Now, I want y'all to remember that this is a motion. This is a petition of memorandum in law in support of the abatement that we filed. Now, we're still got to go over the abatement, the initial little document that goes first before this. For this document right here, this long one, is the support of the initial abatement. Okay, so we're going to continue on though. So it says, and the Constitution for the United States of America at Article 1, Section 10, Clause 1 mandates no state shall grant title of nobility. States it right there. None. You can't give it to me. I don't need it. I don't want it. You can't grant it. Sorry. Try again. And, quote, the establishment of, the prohibition of, titles of nobility are perhaps greater securities to the liberty and republicanism than any the national Constitution contains.
Can you dig it? Can you dig it? Can you dig it?
Nothing need be said to illustrate the importance of the prohibition of titles of nobility. This may be truly denominated the cornerstone of Republican government. For so long as they are excluded, there can never be serious danger that the government will be any other than that of the people. Unquote. Danger equaling nobility government, that of the police state. The Federalist Papers, 484. Alexander Hamilton.
Yes, sir.
A title of nobility is privilege of license, and license of privilege, otherwise such title of nobility ceases to exist without such privilege of license and license of privilege. A license to drive is a title of nobility, in that it is a special grant privilege to use vehicles upon the public highways and roads. So says the Utah Supreme Court cited in Salina versus Wisden Supra. The state of Oregon, falsely acting as a king, grants title of nobility when it takes away a natural existing public or private rights, forbidding a natural activity or occupation to all, then turns around and specially grants it back to a few or many, the special privileges to engage in that activity or occupation, and requiring the obtaining of a title of noble privilege, driver's license, license plate, to drive vehicles, and obeying attending nobility rules as applied to the accused is contrary to the Constitution for the United States of America mandate at Article 1, Section 10, Clause 1. Quote, no state shall grant any title of nobility.
Yes, sir.
Unquote. Hence, Oregon revised statutes, etc., all attendant nobility traffic rules, regulations, and penalties made pursuant to such is to the contrary of the res judicata mandate of the Constitution for the United States of America, lest we be corporate slaves, and it is notwithstanding and void by mere operation of law upon this record as applied to the accused. Hence the court lacks subject matter jurisdiction because of the prohibition of titles of nobility, attendant rules, regulations, and penalties. Looks like we got a case closed on this one, brother. So let's conclude it all. Let's bring it to the end. Let's hit them with the last few punches and be done with it. Conclusion. It is the duty of the courts to recognize the substance of things and not the mere form. The court, quote, the courts are not bound by mere form, nor are they to be misled by mere pretenses. They are at liberty indeed. They are under a solemn duty. 100. They are under a solemn duty. I might as well start speaking up to this next court case I got coming up on January 23rd in the Marion County, Oregon, for the Marion County Justice Court with Justin Kidd, which is a justice of peace. We're gonna see. He's already failed by not recognizing at the arraignment court by calling, again, which they love to say, the game. They love to say, we're not going to play this game.
Biatch!
They don't like it when you don't submit, so they call it a game. But it's not a game.
Biatch!
The ancestors that died for me and you, the millions upon millions that died for our freedom, is not a game.
100.
And when you say it's a game, you disrespecting those who died for us. And we're not going to allow that.
Hey, yeah, boy!
There are good lawyers out there. There are lawyers that stand up and say that they are proud for the people like me and others who stand up to fight against tyranny, to fight against encroaching on our rights, our freedoms, our liberties, for we are creations of the Most High. There's nothing that can control you. You have to get that through. I know I repeat myself over and over, but I can't stop. It's something that you just got to ingrain in you, into yourself. To look at the substance of things, whenever they enter upon the inquiry whether the legislature has transacted the limits of its authority. If, therefore, a statute purported to have been enacted to protect the public safety has no real or substantial relation to those objects or is palpable invasion of rights secured by the fundamental law, it is the duty of the courts to so adjudge and hereby give effect to the Constitution. Unquote. Mulger versus Kansas.
Hey, yeah, boy!
And, quote, it is the duties of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. Unquote. Boyd versus United States in 1889. No higher duty of this court exists than to recognize and stop the stealthy encroachments which have been made upon the citizen's right to travel and use the roads to transport his property in the ordinary course of life and business. Hadfield. Further, the court must recognize that the right to travel is part of the liberty of which a citizen cannot be deprived without specific cause and without the due process of law guaranteed in the Fifth Amendment.
Yes, sir.
Kent. The history of this invasion of the citizen's right to use the public highways shows clearly that the legislature simply found a heretofore untapped source of revenue, became greedy, and attempted to enforce a statute in an unconstitutional manner upon those free and natural men and women, or woman, who had a right to travel upon the highways. This was not attempted in an outright action, but in a slow, meticulous, calculated encroachment upon the citizen's right to travel. And you want to know why it had to be slow? Because those people back then wasn't going to put up with it. They knew that if the government came and encroached upon them, that they would fight armed and ready to go against them by any means necessary to secure the freedoms of not only themselves but their seed, their further generations. See, back then, the government wasn't as big as it was now. There wasn't as much of a Hegelian dialectic, right? The problem, those who create the problem, then give the reaction or create the reaction and then already have a solution to give forth unto you. which is what the government does all the time.
Yes, sir.
You got to understand that they give certain, what is it called? What do they say? Never let a good tragedy go to waste. They create the tragedy. They already know the reaction due to the tragedy. And then they already have the solution to the tragedy that they've created in the first place. Thus, it takes a while to encroach and get to where they want to get, which is total domination and control. But I know that my forefathers, I know that my ancestors weren't allowing it. They weren't putting up with it. They were fighting. And though we do not have to kill for our rights to this day, we can stand up and speak freely and fight against tyranny. All you have to do is stand on your rights. All you have to do is sue. You see what I'm saying? And we can stop this together. It's not about violence, y'all. It's about peace. It's about showing how to operate in a standing of capacity, standing in true sovereignty, the real word of it, not in relation to the whole, I'm a sovereign citizen and I don't, applying what you know, standing on your authority in full capacity. Let's continue. The position must be accepted unless the prosecutor can show his authority for the position that the use of the road in the ordinary course of life and business is a mere privilege. To rule in any other manner without clear authority for an adverse ruling will infringe upon fundamental and basic concepts of constitutional law. This position, that a right cannot be regulated under any guise, must be accepted without concern for the monetary laws of the state. Quote, disobedience or evasion of a constitutional mandate cannot be tolerated, even though such disobedience may, at least temporarily, promote in some respects the best interests of the public. Unquote. Sloat versus Examination. And, quote, economic necessity cannot justify a disregard of constitutional guarantee. Unquote. Riley versus Carter. I like that one. And, quote, constitutional rights cannot be denied simply because of hostility to their assertions and exercise. Vindication of conceded constitutional rights cannot be made dependent upon any theory that it is less expensive to deny them than to afford them. Unquote. Watson versus Memphis.
Can you dig it? Can you dig it? Can you dig it?
Therefore, the court's decision in the instant case must be made without the issues of cost to the state being taken into consideration, as that issue is irrelevant. The state cannot lose money that it never had a right to demand from the sovereign people. Finally, we come to the issue of public policy. It could be argued that the licensing scheme of all persons is a matter of public policy. However, if this argument is used, it too must fail, as no public quote, no public policy of a state can be allowed to override the positive guarantees of the Constitution of the United States, unquote, 16 Am. Juris 2nd Constitutional Law, Section 70. So, even public policy cannot abrogate the citizen's right to travel and use the public highways in the ordinary course of life and business. Therefore, it must be concluded that, quote, we have repeatedly held that the legislature may regulate the use of the highway for carrying on business for private gain, and that such regulation is a valid exercise of the police power. Unquote. Northern Pacific RR. Quote, the act in question is a valid regulation, and as such is binding upon all who use the highway for the purpose of private gain. Unquote. Notice in both quotations, in both quotes, it says private gain. This is not about free will travel. I mean, I shouldn't even have to argue the fact that no man can regulate another man in relation to the way in which he wants to travel. Nobody's going out and telling a man he needs to get a license to ride his horse on the side of the highways. Nobody's stating that you must have to give up your right to ride a bicycle on the roads. It's ridiculous, y'all. Any other construction of this statute would render it unconstitutional as applied to this citizen or any citizen. The accused therefore moves this court to abate this action, or in the alternative to dismiss the charge against him without prejudice. Pursuant to Federal Rule of Evidence 301 and attending state rules, the burden now rests with the plaintiff to bring forward evidence in rebuttal of the facts stated herein by the defendant with law and great specificity, not merely verbiage, and personal convictions and beliefs or the agency's biased legal counsel. Defendant believes that he has made a compelling case in support of his petition for abatement with sound law and legal theory, and requests that if the court rules adverse to that legal theory, that the judge submit a written opinion and conclusion of law. Definition: errors in the defendant's legal reasoning and theory, so that a clear and defined legal obligation of the defendant to comply with existing state statutes relative to his constitutional right to travel is understood and established as a matter of law for the accused and the public at large. Okay. Alright, so we got done with that one, y'all. We got done with that one.
Okay then.
So again, now, like I said earlier, we're getting into the first part of the notice and demand for abatement, okay? And this is the first one that you actually filed. We went through the second part, the actual support of this notice and demand for abatement, which is, and then again, that memorandum of law and support is what we just read through. So let's read through this. And again, this is what you're filing with the courts when you get your tickets if they don't want to respect your right to travel on the roads. Now comes the accused, Cameron Wilson, by his own authority, appearing specially and not generally or voluntarily, so as not to confuse the court, and challenges the jurisdiction of this court. But being under the threat of arrest if he failed to appear, at no time does the accused submit to the jurisdiction and venue of the above entitled court, and at no time waiving any rights whatsoever, knowingly or unknowingly. So when I go into the courtrooms and I first speak to the judge, I read this right off the bat. First thing that I state. I've already filed this, so they know it, but I state it for the court record, okay? First thing I say, so they know right off the bat. I'm not here because I want to be. I'm here because y'all are threatening me with arrest if I fail to appear. But I'm not submitting to your jurisdiction at all. Whether knowingly or knowingly, rights are not being waived, okay? Just not happening. Accused asks the court to take judicial notice of the fact that he is without counsel and is not schooled in the law and legal procedures, and is not licensed to practice law. I also read this, excuse me. Actually, I'm reading all this right here when I first go into the court. And if they try to interrupt me, I keep on reading. Because I know that I'm of the highest authority. I just keep reading, I don't stop. And they're not going to interrupt me. And don't allow them to interrupt you and stop. Okay? Therefore, his pleadings must be read and construed liberally. See Haynes v. Kerner, 1980. Burrow v. Estelle in 1981. Further, the accused believes that this court has a responsibility and legal duty to protect any and all of the accused's constitutional and statutory rights. See United States v. Lee, 1882. The accused gives notice that this action be abated or dismissed immediately, or show cause why the accused should not take all lawful recourse against the accuser for willingly and knowingly violating my rights under Title 18 U.S.C. Section 242. Determination of material facts via tacit procuration. Number 1. Can the state legislature, with the power to make all statutes, laws, and needful rules, abrogate by that power the citizens' constitutional guarantees? Oh my gosh, look at me. Number 2. The accused is possessed of all rights pursuant to the Constitution for the United States of America, the Constitution of the Oregon State, common law, and the rules applicable to criminal procedure. 3. The accused makes this special appearance in order to determine what rights will be afforded him by this court and which rights will be denied. 4. Due process requirements of the federal and state constitutions require, among other procedures, that the accused be furnished by the plaintiff with a verified complaint of injury, so that the accused may consider a plea other than guilty. Now, this is a big one because they cannot provide that to you. There is no verified complaint of injury. There is no injury. You've caused no harm or injured nobody. They're violations. There's no crime that's been committed. Okay? Number 5. By the plaintiff not being afforded this fundamental right, he cannot determine the nature of the offense he is being charged with that has caused damage to the plaintiff, of what plea other than guilty is available to him. Number 6. By denying the accused the accusatory instrument, the court is denied subject matter jurisdiction, and there is no valid charging document before the criminal court at the time of this arrangement. Number 7. Absence of a verified complaint or information denies the court of subject matter jurisdiction, and even if the accused appears in court, the judge cannot arraign him unless the accusatory instrument has been filed. Number 8. In order for the court to have subject matter jurisdiction, the police officer who was issued and served the traffic ticket must, at or before the return date, file with the criminal court a misdemeanor complaint, a simplified information or an information charging the person named in the appearance ticket with the offense specified therein. Number 9. It may be that the court has a misunderstanding of what the law requires that the signed appearance ticket is sufficient document upon which to arraign Cameron Wilson. 10. The appearance traffic ticket utterly fails to meet the requirements of an accusatory pleading in that it fails to state the title of action, the name of the plaintiff, or contain a statement of the public offense which it allegedly charges. It fails to constitute a accusatory pleading, since it is not sworn to before some officer entitled to administer oaths. 11. In addition, the appearance/traffic ticket is not subscribed by any prosecutor. It is signed by the police officer, but he is only a witness and is not identified as one who is authorized by law, who may be a prosecuting attorney representing the people. 12. As the prosecuting attorney does not ascribe to the appearance/traffic ticket, the people of this great land known as Oregon have not charged the accused with any crime whatsoever. 13. Without an accusatory instrument subscribed by the prosecuting attorney charging the accused with a crime, there is no charge for Cameron Wilson to plead to or defend against. 14. The accused Cameron Wilson has met the plaintiff, whoever that may be, step by step, by the special appearance as he agreed to and promised in the appearance/traffic ticket. It would be the plaintiff who has chosen not to prosecute by not filing a verified complaint, therefore depriving this court of any jurisdiction. Okay?
Hey, yeah, boy.
So there it is. That's the first one that you file. And that one's going to hit them pretty hard to where they're not going to know what to do. They can't. They can't fight you. For a charge to be brought against you, there has to be a verified complainant of the people. There has to be a VC, verified complainant. If there's no verified complainant, and that's what I always state within these court proceedings, where is the verified complainant? They can't bring one forth.
Yes, sir.
The police officers work for the corporation. They can't be one of the people in that capacity. It doesn't work. You guys have to understand how the law works, y'all. So this is a document that I use sometimes I don't. Sometimes I'll use it just as another element to another motion to bring into the court, right? Because it has some good things in here that is said as well. I use this in a case against Battleground City of Washington and Richfield City of Washington, as well as the state of Washington. This is a motion to strike or dismiss. It says, now comes Cameron James Wilson, a natural individual, alleged defendant in error by special appearance not submitting to the court's jurisdiction, who hereby moves this court to strike or dismiss the complaint filed by Officer David Sim for lack of ratification of commencement, no corpus delicti, no plaintiff, and lack of personam jurisdiction. Grounds are set forth below. 1. Objection for lack of ratification of commencement. There is no claim. Federal and State Rules of Civil Procedure, Rule 17a, Real Parties and Interest. Quote, every action shall be prosecuted in the name of the real party and interest, an executor, administrator, guardian, bailee, trustee of an express trust, a party with whom or in whose name a contract has been made for the benefit of another, or a party authorized by statute may sue in that person's own name without joining the party for whose benefit the action is brought. And when a statute of the United States so provides, an action for the use or benefit of another shall be brought in the name of the United States. No action shall be dismissed on the ground that it is not prosecuted in the name of the real party in interest until a reasonable time has been allowed after objection for ratification of commencement of the action by, or rejoinder, or substitution of the real party in interest. And such ratification, joinder, or substitution shall have the same effect as if the action had been commenced in the name of the real party in interest. Federal Rules of Civil Procedure, FRCP Rule 1, quote, there is one form of action, the civil action, unquote. Let's take a look at what this rule is saying. Quote, no action shall be dismissed after objection for ratification of commencement of the action by real party in interest, unquote. What is ratification of commencement? It is a claim. No one has a claim in government. They can't have a claim. They are neither injured nor trespassed. Uh-oh. We getting somewhere now, huh? See, I told you there was some good stuff in here, bro. I believe that this ratification is the piece that comes before the question of claim. And if someone alleges they have a claim, then they have to produce the ratification of commencement. According to the Federal Rules of Civil Procedure, FRCP Rule 1, there is only one form of action, a civil action. This is important because 1. All crimes are commercial, 27 CFR 72.11, and 2. Every alleged crime has to have a nature and cause, and be prosecuted in the name of the people of the state as the real party in interest, not the people of the state of Washington, or the people of the state of Washington, as that is the corporation and is a possibility. There is neither an injured party nor trespass. All crimes are commercial, as indicated at 27 CFR 72.11, and every alleged crime has to have a nature and cause and be prosecuted in the name of the people of the state. 2. There is no corpus delicti. Crime is a breach of laws or governing authority. While this alleged offense or violation was a violation of the law, it was not a crime. As my limited comprehension permits, these matters are criminal. Notwithstanding, proof of the corpus delicti is required in all criminal matters. Quote, proof of the corpus delicti is required in all criminal matters. Verbatim. There are 3 basic elements in the proof of a crime. 1. The occurrence of loss or injury. 2. Criminal causation of that loss or injury. And 3. The identity of the defendant as the perpetrator of this crime. However, it is firmly established in this state that the term corpus delicti embraces only the first 2 of these elements, loss or injury, and criminal causation. Unquote. State versus Hill. Quote, it is true that the above are all cases of felony homicide, but the doctrine of corpus delicti is in no wise peculiar to such cases. It is equally applicable to all criminal cases. Unquote. State versus Gelzer. 3. There is no plaintiff. This is an adversarial proceeding, and as it is to the alleged defendant's limited comprehension, adversarial proceedings require real adversaries. Quote, properly understood, the general principles is sound, for courts only adjudicate justiciable controversies. Courts must look behind names that symbolize the parties to determine whether a justiciable case or controversy is present. Unquote. United States versus Interstate Commerce Commission, 1949. 4. Lack of evidence alleged defendant was operating a vessel in commerce. It has not been established that the alleged defendant is subject to this private law by way of explicit or implied contract. Alleged defendant's acceptance of alleged citation was under duress for fear of arrest and was not meant to be a contract with the state. Quote, no state government entity has the power to allow or deny on the highways, byways, nor waterways transporting his vehicles and personal property for either recreation or business, but by being subject only to local regulation, i.e. safety, caution, traffic lights, speed limits, etc. Travel is not a privilege requiring licensing, vehicle registration, or forced insurances. Unquote. Chicago Coach Company versus City of Chicago. And y'all already know this one. Quote, the court makes it clear that a license relates to qualifications to engage in profession, business, trade, or calling. Thus, when merely traveling without compensation or profit outside of business enterprise or adventure with the corporate state, no license is required of the natural individual traveling for personal business, pleasure, or transportation. Unquote. Wingfield versus Fielder, 1972. Now, this one we haven't read in the other one, but this one's a really good one as well because, I mean, look at it. It's in 1972. It says no license is required of the natural individual traveling for personal business, pleasure, and transportation. Like, what don't you get about that? Like, I'm, like, lost. Like, if what's going on is that if these courts don't rebut what you're stating and they continue to convict you anyways, that is treason, guys. That is treason. It is a clear violation under Title 18, Section 242 of USC. Like, pursue it. Get them off the bench. If they are not going to respect the Constitution and those who died because they're so worried about generating revenue and giving a facade to everybody that is out there, it's ridiculous. Why not stand up? Why is that so hard? Why not say, you know what, I appreciate you standing up and fighting tyranny. I've been waiting for someone like you to come across here so that I can think. Because this is all I've ever wanted to see, is someone who has intelligence and wisdom of the rights that they have, citing case law to come into my court and challenge the jurisdiction and having all authority. I mean, hello? Quote, traffic infractions are not a crime, unquote. People versus Battle. That's very simple and to the point. Quote, for a crime to exist, there must be an injured party. There can be no sanction or penalty imposed on one because of this exercise of constitutional rights. Unquote. Scheer versus Cullen. Quote, under our system of government, upon the individuality and intelligence of the citizen, the state does not claim to control him or her except as his or her conduct to others, leaving him or her the sole judge as to all that affects him or himself. Mulger versus Kansas. Now that right there is a big one too, but again, it all comes down to what do you know and what do you not. This is a free world. You have all will to choose, to know, to understand, to imply, to comprehend, not to stand under or to understand, but to stand over and overstand. 5. Lack of evidence. Alleged defendant was violating the private statute. Alleged defendant was not traveling erratically, not engaged in any taxable activity, and is not in contract, treaty, or agreement with the state of Washington or Oregon or whatever state, as herein evidenced by attached. And I think these are some revised codes of Washington that I applied to this motion here. So it says 1. No person shall drive a vehicle on the highway at a speed greater than is reasonable and prudent under the conditions and having a regard to the actual and potential hazards then existing. In every event, speed shall be so controlled as may be necessary to avoid colliding with any person, vehicle, or other conveyance on entering the highway in compliance with legal requirements and the duty of all persons to use due care. Now, I agree with that. We should be careful of other people because we don't know their age. We don't know their level of experience in driving. And being a victim of... I don't even want to say a victim. Being a person who was involved in a significant car accident, I can agree with this because I'm an amputee because of a car accident. Like, I lost my leg because of a car accident. So I think that being cautious on the roads is something we do need to do. I think it's you know, I keep at least 2 to 3 car lengths distance from the person that is in front of me. I don't care if we're in bumper to bumper traffic. I get honked at and screamed at and flipped off all the time because I'm not riding someone's ass. But I would rather be safe, man. Like, I would rather be safe. And that's just going through personal experiences. Then it says exceeding the speed limit evidence with reckless driving. Of course, you know that's crazy. I don't do that either. But let's go through some general reservation of rights. Please be advised that my use of the phrase all rights reserved without prejudice below my signature on this document means That I explicitly reject any and all benefits of the Uniform Commercial Code, absent a valid commercial agreement which is in force and to which I am party, and cite its provisions herein only to serve notice upon all agencies of government, whether international, national, state, or local, that they, and not I, are subject to and bound by all provision, whether cited herein or not. 2. My explicit reservation of rights has served upon notice upon all agencies of government of the remedy which they must provide for me under Article 1, Section 308, previously 1207 of the Uniform Commercial Code, whereby I have explicitly reserved my common law right not to be compelled to perform under any contract or commercial agreement that I have not entered into knowingly, voluntarily, and intentionally. 3. That my explicit reservation of rights has served notice upon all agencies of government that they are all limited to proceeding against me in harmony with the common law, and that I do not and will not accept the liability associated with the compelled benefit of any unrevealed commercial agreements. And 4. My valid reservation of rights has preserved all my rights and prevented the loss of any such rights by application of the concepts of waiver or estoppel. Conclusion. It is reasonable to assume that these judicial decisions are straight and to the point, that there is no lawful method for the government to put restrictions or limitations on rights belonging to the people. There is no question that a ticket or violation issued by a police officer for no driver's license, current vehicle registration, or mandatory insurance, and etc., which carries a fine or jail time, is a penalty, and is indeed converting a right into a crime. A corporate entity, whether it be city, state, or U.S. government, cannot testify as an injured party, thus cannot be cross-examined. As an individual, one can speak for a corporation, but cannot be an injured party. If the alleged defendant is to be subject to the alleged criminal acts, it is concluded that no act was in fact broken, because there is no ratification of commencement, no plaintiff, the court's lack of personam jurisdiction, and no corpus delicti, thus no justiciable controversy or cause of action before the court. Alleged defendant asks the court to strike or dismiss the complaints filed. Okay, and when you sign things you want to do in sui juris capacity, all rights reserved. Okay, you can put beneficiary 1-308. You can do all kinds of things, but all rights reserved. The reason for that is because if they still want to find you guilty and they want to attach it to the collections aspect to it, they're going to have to go after the straw man. Okay? Because the living man is not the same as the straw man or the trust. Alright? So let's get on to some of this proof y'all wanting to see in relation to the dismissal in which I presented to the police officer of Hood River. Let's get to it. So, we're taking a look right here. This is the motion that I filed. You'll see the last four is 1739. Again, just kind of zooming in here so y'all get a better understanding of that we really did file these, man. And then you'll notice here the tickets in the background, the infraction. You'll see the same motion to strike or dismiss. Here's the filing of those same ones. You'll notice there case number, no valid operator's license, 9/1/22. And then here is the dismissal on the same day, 9/1/22. Please let the court know how you would like to proceed with the other infractions. Waiver to the right of attorney, because I'm pro se, baby. It'll even, look, defendant, it says comprehend on my signature, because I said comprehend and I do not understand or stand under. You see the pretrial, the court ruling regarding, you see pro se there. So what you'll notice, last four, 1739 in the municipal court order, plaintiff dismissed without prejudice on the motion of the plaintiff, City of Ridgefield, right? You can see it right here. Again, last four, 1739, no valid operator's license without identification. Then it says when? September the 1st, the arraignment, the court setting. That's when I went there on the arraignment, spoke up, and then look, on the same day, that's when they dropped it, bro. 1739. Here's the filing of the motion, August 30th, on everything that we just read through, guys. On everything we just read through, guys. Come on, man. Ain't no bullshit around here. This one got filed too. Motion to strike and dismiss. We just got done reading that, guys. Okay, and this was the copy that I had submitted, but this was the one that was filed. Okay.